Thank you. Please be seated. This is a time scheduled for oral argument, in our case, AEA Federal Credit Union Yuma versus Yuma Funding, Inc., CA CV150753. Good morning. We are delighted to have you here. We're also delighted to have Mark Moran, Coconino County Superior Court presiding judge, sitting pro tem with us. Mark, thank you for your service. Each side is allocated 20 minutes for your arguments today. If appellant, if you wish to reserve some time for rebuttal, please do so, but please keep track of your own time using the podium clock. We will not do that. Out of respect for counsel, those present, please make sure your phones are turned off so counsel's argument is not interrupted. We have read the briefs. We're familiar with the record. We've conferenced the case this morning. We'd encourage you to keep that in mind as you present oral argument. Our arguments are being posted both on the court's website and then on YouTube. So please, as you begin your argument, tell us your name and the party that you represent. With that, Mr. Kelly, you may proceed.
Thank you, Your Honor. May it please the court, Jason Kelly for defendant appellant Yuma Funding Incorporated. And I know I'm going to try to reserve some time for rebuttal, but I don't have a whole lot to say, so I don't know how hard it will be. The question, I think, before the court is whether on an ex parte basis a freeze order can be entered, allowing the plaintiff to seize all of the defendant's assets, cash in on those assets, and never hold a hearing. I think Rule 65 is pretty clear, and I think there were injunctions in the January 2010 order. The uncontroverted case law says that freeze orders are in the nature of TRO relief, and Rule 65 is pretty clear that any injunction entered ex parte, I don't know what the word is, evaporates, ends 10 days after its entry. The record's clear. There was never a hearing. The record's clear that the plaintiff got everything it wanted in its complaint on the basis of an ex parte order. And just to, I really want to drive this home. The thrust of the answering brief was the trial court didn't mention Rule 65, but I think if it walks like a duck and quacks like a duck, it's a duck. If review of the order itself, paragraph 3A on page 2, the Yuma trial court sequestered all of Yuma Funding's assets. Paragraph 3B, which goes over pages 2 and 3, Yuma Funding was ordered to turn all of its property over to the receiver. The order at paragraph 3C, Yuma Funding was enjoined from touching its own cash and assets. Paragraph 3E, Yuma Funding was enjoined from acting to, quote, impede, obstruct, hinder, enjoin, delay, or otherwise interfere with any steps taken by the receiver to operate or manage Yuma Funding. Yuma Funding was also at paragraph 8 on page 8 enjoined from prosecuting or defending any legal actions. Therefore, the trial court on an ex parte basis put total control of Yuma Funding and its ability to defend itself into the hands of the receiver. It gave all of Yuma Funding's assets and incomes to the receiver, who then turned it over to AEA. And, you know, importantly, it denied, this was it was a family-owned, closely held company, but this was their asset and income base. And normally, if, for example, Ford or Google got sued, the shareholders wouldn't be required to come up with money. But, you know, even having said that, the shareholders in this company had nothing within a matter of months. There was nothing that could be done. This company was dismantled and dissolved and looted within 6 months. We came back and, you know, there was some discussion in the answering brief that the receiver is an arm of the court, and that's true. But frankly, the receiver was unnecessary because the receiver just acted as a funnel to take all, again, 100% of Yuma Funding's assets and gave it to AEA. Complete relief on the complaint, perhaps in excess of the claimed amount due. You know, we're taking the appeal from the October 2015 order. That order denying our motion to quash, which again, our motion to quash was just apply the plain language of Rule 65. The order denying that request explicitly recognized that it had issued injunctions and that the injunctions included a freeze order. And I cited, and it was important, I cited to the record the transcript and oral argument, pages 24 to 26. I said, Judge, if they're still performing promissory notes, does AEA get to keep collecting on them? The judge said yes. So everyone here understands what happened. But what the trial court failed to do was enforce Rule 65. The question, this appeal is all about Rule 65 and the due process safeguards. When Rule 65 and the due process protections are violated, what's the remedy? The remedy is it's unwound. It's void. It's either the ex parte order itself is void ab initio because it says all of these injunctions will remain in place until further order of the court. If alternately, though, if the panel doesn't agree with me, the parties need to be returned to 10 days after the issuance of the ex parte order. The uncontroverted case law, uncontroverted, is that when there's a void order, you go back to the status quo, and everything that occurred after that order is unwound.
Counsel, let me ask you, because this, and I appreciate your argument, this case has, from my perspective, and I suppose all cases do, but this one in particular, a unique procedural history. We have
Agreed.
The January 2010 order that puts a receiver in place and does a whole bunch of other things that you take issue with in this appeal. But the fact remains that that order was in place for 5 years, something like that. You then, what resulted in the October 2015 order is a motion to dissolve the injunction and to do other things. And the court granted the motion to dissolve, but denied the request to do kind of the other things. That's one way of looking at where we are. And what I would like for you to address, and the answering brief talks about this, but we're always cognizant of our appellate jurisdiction. And what is the basis for our appellate jurisdiction to consider that ruling at this time?
I think the case has already been decided. Is that the Grammett case or something, the consolidated appeal? Brummett versus MGA Homes, 240 Arizona 421. I think it's already been decided.
I think that case,
Paragraph 19.
I think that case said that the question was whether 54B or C language was required from an order dissolving an injunction.
Fair enough.
An appeal from that. Now, and I think it said no. Under 2101, you don't have to have 54B or C language to appeal from an order dissolving an injunction. But if you look at what you requested just with respect to the dissolution of the injunction and not the everything else, which I think is what you're really concerned about here, the court granted that motion.
The court denied our request to return us to the status quo.
And that's what I'm talking about, the everything else. But it granted your motion to dissolve the injunction, and then it didn't, apply that retroactively, direct that you get all your papers back, direct that you get property back, things, the other stuff, if you will. Is that a fair way to look at this?
Well, I understand what the court is, what Your Honor is asking. I would submit that that's putting form over substance. The trial court says, I dissolve the injunction, but I'm not going to do anything. I'm not going to give that dissolution any meaning.
And I understand your point on the merits, but jurisdiction issues are the first question we have to address. And it is fair to look at 2101 and say at times that does put form over substance. I mean, that's kind of how appellate jurisdiction works. And if we issue an order where we don't have appellate jurisdiction, it is void in the same way that you're arguing the initial injunctive relief was void. So that's what I'm struggling with.
I understand. Your Honor, it says, the order says, I, Superior Court, dissolve the injunction. Right. That's not what it did, though.
Well, it did that, but it didn't do a whole bunch of other things that you asked it to do.
Didn't do anything.
Okay.
It asked it to.
I thought it dissolved the injunction going forward.
Well,
now, if I'm wrong, help me, because
it dissolved it on a going forward basis. Okay. Yes. But see, even that, I mean, this is why those pages 24 to 26 of the transcript are important. The court said, I'm dissolving on a going forward basis, and I said, well, return the assets, and the court said no. That's why I asked that question. I wanted to get clarification on that point. Because in substance, when I said, okay, if it's going forward, can you at least give me back the money that is there? And the judge said no. He refused to dissolve. He called it a dissolution, but he didn't do it. Even on a going forward basis, he didn't do it.
And help me understand that, because it would strike me that if actions have been taken pursuant to receivership or an injunction over a period of 5 years, and then the injunction is dissolved going forward, that is a dissolution of an injunction if additional relief is sought, and I absolutely see your motion as requesting a whole bunch of other things. That is sort of different than whether the injunction's in place going forward, and help me understand why I'm wrong.
Sure. You have to understand the nature of the assets taken. They were promissory notes, payments over time.
And you wanted the paper back, right? You wanted the proceeds back. You wanted the books and records back.
And I don't know, because I haven't seen it.
I'm asking, is that some of the things you wanted?
And let me put a little finer point on it.
Sure.
And because I haven't seen it, still haven't seen it. But if, for example, there's a promissory note that is to receive payments on a date after October 1st, 2015, and the injunction is truly dissolved, wouldn't my client get those proceeds?
Well, it depends on what other relief you requested as opposed to the injunction going forward. You're asking for, if you're saying the injunction, if the relief granted was the injunction never should have issued and therefore was void from the beginning, I completely understand that. But that's not the ruling we have coming here. That's the argument you make, but that's not the ruling we have.
The request I made was it should be void ab initio, and the judge denied that.
I understand that.
And he refused to dissolve it because he says it wasn't void ab initio.
And the question that I have with respect to the first inquiry we always ask, which is appellate jurisdiction, is how does that fit within appellate jurisdiction?
Because the injunction, I'd really ask the court to focus on, let's say, for sake of argument, the judge claims he dissolved the injunction. So for the appellate jurisdiction, was the injunction dissolved? The answer is no, because if there's still any performing assets, my client did not receive them. Therefore, he didn't refuse to dissolve. It's an order refusing to dissolve the injunction. It's not a request for monetary damage. It's not a request for relief. It's a request to undo the equitable injunction, the freeze of the assets. Judge, unfreeze them. Return them.
If the court had granted you everything you asked for in the Superior Court, and clearly the court did not, to conclude that the injunction was void as of January 2010, should never have issued, and that you undo that, you make that finding nunc-pro-tunc January 2010, what would that look like? How could that happen? I mean, there are 5 years of activities that have happened. How do you undo all those as a practical matter? AEA
is sitting on the money and was holding it. It can be returned.
Your point is, I think, though, that none of the actions that were taken should have been taken in that 5 years. None.
Zero, because it was void.
And how does that order read?
It reads, return the assets taken and any proceeds gained from the promissory notes. If necessary, we appoint some sort of special master to do an accounting.
Okay. And is it your position that the receiver is still in place in this, or the receiver has been relieved?
Well, I think the receiver made about 3 or 4 attempts to get relieved. I think the last one was effective over my client's objection.
So the receiver has been relieved of any obligations, is no longer part of this case?
I need to review the record.
Let me share with you, I struggle with answering that question. I'm not asking it, sort of thinking I know the answer. I really don't. And that's why I struggle.
Well, the receiver in this July 2010 or June or July 2010 order was ordered to do a final accounting, which he never did. But I think the judge did issue some sort of order allegedly relieving him. So while it says he's relieved, he hasn't completed his duties. So I don't know, that's another issue for appeal if we ever get to that point. I mean, I don't know how that is supposed to work, where a receiver's appointed, does not do an accounting, but the trial judge thinks he's exonerated. But does Your Honor have any more questions on this?
I do not. Let me look to my colleagues. None at this time.
Well, I do, if we look at what happened, and again, it's important to get to the substance of the order. And is there appellate jurisdiction for an order refusing to dissolve an injunction? The answer is yes. The court says it dissolved the injunction, but then in practice did not. If we state the simplest one going forward, if there are performing promissory notes that are payments due on November 1, 2015, the judge says you're not entitled to that. I'm going to keep it frozen and in their hands. That right there is a refusal to dissolve the injunction and unfreeze the freeze order. If we go backwards, again, we asked them to dissolve it because it was void. He said it wasn't void. We followed due process. We followed Rule 65. So again, he refused to dissolve it, sustaining the plaintiff's objections. So I do believe, under the statute, this court has jurisdiction. If it was as simple matter as saying I'm going to dissolve it but not grant relief and therefore avoid jurisdiction, it'd be really easy to evade review. And I'll save the rest of my time for rebuttal. Thank you.
Thank you, counsel. Mr. Olson.
Good morning, Barry Olson. I represent the plaintiff appellee AEA Federal Credit Union. I don't have a whole lot to say. Obviously, it's pretty clear to me that the court has reviewed our brief and the positions of AEA. So if there are any preliminary questions that the court has that it would like me to address, I'd be more than glad to do so.
Please proceed.
All right. I think the first point we want to make is let's go back to where this case started back in January of 2010. There was the order appointing the receiver, which has already been before this court on a prior appeal on a reported decision where this court determined that there was no jurisdiction to set aside the order appointing the receiver as there was the appeal was untimely. That's the only order that was issued in January of 2010. What Yuma Funding is attempting to do is an end run or collaterally attack that same order. And now its position before this court is, well, it has a problem with the injunction language that was couched in a couple of paragraphs of that original order. So Judge Plant in October of 2010, and I stipulated to it on behalf of AEA, saw no need for the injunction any further given the July 2010 order where the receiver was discharged in order to turn over the collateral to AEA. But if you go back to that injunction language, it's not Rule 65 injunction language. It's essentially ancillary to the Rule 66 order appointing the receiver. But if you even take it a step further and you adopted Yuma Funding's argument, which I believe is not on base, if you were to, I'll come back to the jurisdiction issue in a minute, if you just blacklined out or redlined the injunction language in that order, it doesn't accomplish anything. What Yuma Funding continues to miss is the fact that an injunction language was simply to allow the receiver to do his job, to collect the assets, to perform his duties in accordance with the court's orders, and to turn over AEA's collateral to AEA, which happened in a short period of time, in I think less than 6 months. So with that in mind, you can't take it the step that Mr. Kelly wants to take it and say, well, because the injunction was issued, AEA would have to give all the money back. That's not what would have occurred, because the injunction was simply do not disturb or interfere with the appointment of the receiver.
Well, didn't that January 2010 order, though, require affirmative acts on behalf of Yuma Funding? I mean, it was not just sort of a snapshot. It required some action by them. Your argument is so that the receiver could properly serve as receiver. Yuma Funding's argument is, well, wait a minute, that was improper. You can't do that. So I understand what you're saying, but it did more than just sort of freeze time. It required Yuma Funding to take affirmative actions.
Yes, back in 2010. And then the way that the case progressed, and you're right, this case has an interesting procedural history. I mean, we haven't even gotten past filing an answer yet. We're still on a motion for default 6 years later. But if you go to the jurisdictional issue, which I think is the crux of this, the court in its decision after the prior appeal basically determined that in paragraph 19 that Yuma Funding's failure to properly and timely appeal the order appointing a receiver deprives the court of jurisdiction. And we're still talking about that exact same order. And so given the fact that this is nothing more than a collateral attack on that original order, if an appeal was to have been necessary by Yuma Funding, it would have had to have filed it within 30 days of the entry of that order back in 2010. It didn't do that. And then if you get to the other aspect of the jurisdiction that we address in our reply brief is the other part of the jurisdictional statute that has to do with the jurisdiction for an order granting or dissolving an injunction. Yuma Funding received or obtained exactly what it was requesting. The injunction was dissolved. It essentially, again, was moot. The only part that it's trying to hang the hat on, or its hat on, is the fact as well it didn't do it retroactively. Well, I don't know if this court has jurisdiction to go in that far into the order to determine whether or not the court had jurisdiction not to dissolve the injunction retroactively. So it gets to the point is Yuma Funding actually an aggrieved party with standing to file an appeal? And it's our contention it is not an aggrieved party.
Doesn't that require us, though, that analysis, to split the October 2015 order in kind of into pieces? The one being the dissolution of the injunction, and the other portion being kind of all the other relief that was requested by Yuma Funding. Well, I mean, and your argument is with respect to solely the dissolution of the injunction, Yuma Funding isn't aggrieved because
correct.
They got what they requested, but they requested a whole bunch more things that they didn't get. Is that fair?
Yes, I don't know if I would. If you look at the pleadings, that wasn't really couched in the injunction. They were asking to dissolve the injunction. What was also filed, as part of the record, was a motion to disgorge assets, which the court declined.
Right.
And so that's not part of the injunction.
It's part of the relief that they seek to challenge, and I thought it was sort of subsumed in that October 2015 order, which is the subject of the appeal. And one of the questions I have for both sides is how fine do we parse that order? If it is treated as one big thing, the dissolution of the injunction, we probably wouldn't have jurisdiction because Yuma Funding isn't aggrieved. If we look at the specific requests that they made, which were in part granted, the dissolution, and in part denied, that be retroactive, that they get the return of certain things, then the question is, for that other part, do we have appellate jurisdiction at this time?
You may ask to the other part. I can recognize that if it's within the context of the order or the ruling as to the dissolution of the injunction.
Okay.
But again, I may be repeating myself, but it goes back to my point of, okay, so what? It gets you, so if you take out that injunction language as of 2015, all that does is say Yuma Funding can't interfere with the receiver's conduct, but the receiver had been discharged 5 years prior to that.
When was the receiver discharged? I'm stumbling a little bit with finding that crisp order.
Well, the order wasn't exact, but there was an order that basically required the receiver to turn over the assets and file a final report in July of 2010.
And I see that, and I see the motion that leads up to that, which talks about a timeline for dissolution of the receiver. But I was sort of looking for that crisp, here it is, you're done, there's no more receiver here, and I didn't find that.
There isn't such an order in the file in this, and the reason for that is if you've seen it, I guess I'm sort of the passenger that now is in the driver's seat in this case because I didn't start the case. But what I do know, when I got involved in the case, it essentially was a dormant case, and you can see that in the record where July of 2010 occurs, the receivers specifically ordered turn over the assets to AEA, and the court's rarely aware of what these assets were. They're performing car loans on a used car dealership. So AEA has continued to collect all of those loans. Matter of fact, I think you can obviously recognize that that was 6 years ago. I think all of these loans have paid off by now. They may have been paid off by October of 2015. But after that, there was really nothing. And then what happened in December of 2012, when Yuma funding appeared for the first time with different principals and legal counsel, we've never gotten to the point of addressing all these issues because, frankly, we've been in front of the Court of Appeals, I think, for the majority of the time since December of 2012. Those are the key points I'd like to make. Again, if the court has any questions, I'd be more than glad to address.
So I'm assuming then, Mr. Olson, that the receiver is no longer actively participating in monitoring any assets of Yuma funding that were initially frozen, and also that since the bond's been discharged, that's no longer a factor and that we need to think about.
Correct. The receiver hasn't had any function in that capacity.
Thank you.
Thank you, Counsel.
Thank you.
Mr. Kelly, rebuttal.
Following up on a couple points, Judge, I was reviewing my record. The record is 196 on November 24th of 14. Oh, no, I'm sorry. Well, there was, at 196, there was an opposition to the receiver's renewed motion for discharge in November of 2014. So I just found that quickly. Sometime, probably a month or so before that, there was a renewed motion to discharge. So as of 2014, the receiver wasn't sure of his role. But what we do know, as the panel asked, 6 months after the freeze order went into place, the court authorized AEA to take all the assets and collect on all the assets. So, when you really look at what happened, and Mr. Olson said it, the receiver was there to get Yuma Funding's assets and give them to AEA, and this all happened within 6 months. So that's really the only time frame you have to look at. If the court's concerned about it took 2.5 years for the principals of the company to find money to get involved, you don't have to worry about 2.5 years. All you have to really worry about is 6 months, because in 6 months it was over. It was over. And as the court pointed out, Yuma Funding and everyone associated was enjoined from doing anything. So when we ask about jurisdiction, and I think, the court asked a few pointed questions, and Mr. Olson admitted, or I think he said he'd have to admit, that there was jurisdiction as to what happens if you dissolve the injunction. Finding, I don't know how else to relate it, but if you go to trial and you're asking for money, you have to get liability and damages. Well, the judge purportedly found for us on liability and dissolved the injunction, in my analogy, but didn't award any damages, didn't award any relief. So again, if the court, and the court is validly concerned with jurisdiction, but if the court is concerned with jurisdiction, think about this. If all the trial court needs to do to avoid appellate review is to say, I'm dissolving it without granting any relief, then there would never be any substance there would never be a review of anything of substance.
And counsel, I understand what you're saying. The concern that I have is not that it would never be reviewed. It's just whether that aspect can be reviewed. The other stuff that you asked for could be reviewed absent 54B or 54C certification. So my concerns are not whether this court would ever have jurisdiction. It's whether we have jurisdiction now.
Well, I think the 54B question's been answered. And the court, Your Honor, asked, how fine can we parse it? I think you can parse, look at the order, see the relief requested, and decide whether or not it was properly withheld. If I came in and if I was just restrained from going to my, say, for example, going to my ex-wife's house, and I said, well, it's more than 10 days old, I want relief, the judge says, well, I'm going to dissolve the injunction, but you're still not, I'm not, but if you show up to your ex-wife's house, then you're still going to get in trouble. I mean, that's what this is. This says, well, I'm dissolving it, but I'm not granting any relief. I'm dissolving it, but I'm not doing, I'm saying I'm dissolving it, but I'm not doing what you asked for.
Why do you think the 54B issue has been resolved?
Because Rule 54 deals, well, the Grammett case, I'm sorry, I'm mispronouncing it.
Brummett.
The Brummett case says 54B is not required for, under whatever, 12-21A, what is that? A5B, 21.
Yeah.
I'm mumbling, but I think paragraph 19 of the decision, which I can't recall the name of, says that it doesn't deal with judgments.
For an appeal of an order dissolving an injunction,
Or refusing to dissolve.
right? And I think Applee's point is you got that. You're not aggrieved. You're aggrieved by other things maybe. They wouldn't maybe concede that. But the injunction is dissolved. It's these other things that you absolutely can appeal from at some point. And the question is whether now's that point, absent 54B certification.
And that's why I drive home when we're talking about the substance of the order. If, and I don't know the answer, I just don't. But if there's notes that we're collecting money past October 9th, I believe, of 2015, and the order was truly dissolved, my client should be collecting those proceeds. And the judge says, no, you're not entitled to.
Where is that in the October 2015 order?
That's in the pages 24 to 26 of the transcript.
Transcript, okay.
So if you just, and you know, when you talk about parsing it, I mean, I think that's just the easiest part. The court can just grant that relief, I suppose. But that's my point. That's my whole point. He said, no, you can't have your assets back. Unless there's any other questions.
Thank you, counsel.
Thank
We
you.
appreciate your briefs. We appreciate your argument today. As we have indicated, this is a unique case, and we appreciate your insight. We will take the matter under advisement. We'll issue a written ruling in due course. And we'll also take a break while we set the courtroom up for our next oral argument. Thank you. We stand in recess.